today's session is on holiday pay. Why are we talking about this particular topic at this particular point in time? If we move on to the next slide, I'll reveal all. So we seem to still be talking a lot about the complexities of holiday and holiday pay. I was reflecting the fact that 10 years ago, 2014, we were doing seminars, in-person seminars on what should be included in normal pay, backdating of holiday pay claims, and lots of multiple holiday pay claims being brought in the employment tribunals, some of which are still there. So it's a bit depressing in some respects that we are still talking about holiday pay in 2024. Well, why is that? If some of you were really enjoying your festive periods, then you would be forgiven for not spotting that the Employment Rights Amendment, Revocation and Transitional Provision Regulations 2023 came into force on the 1st of January 2024. And those have made significant changes to the UK Working Time Regulations 1998. But before we get to that, it might be useful for us just to go through a little bit of how we've actually gotten to this particular point. Those of you with good memories will remember that when we left the EU, there was a piece of legislation called the EU Withdrawal Act 2018. And what that did was that it was designed to try and stop all of our law just disappearing overnight. So it retained all of the EU law into our domestic legislation and created a new category of law called retained EU law. That's all sounds very clear, but that included all EU-derived law that was in place at the end of December 2020. And that was the end of the transition period. So that included all domestic legislation which implemented EU law, and the Working Time Regulation obviously implemented the Working Time Directive. It also included a lot of, or brought into our domestic law, a lot of the ECJ decisions, and you'll know that there were a lot of ECJ decisions on the issue of holiday pay, and also our own domestic cases, which involved the application of EU law. And again, there have been a lot of domestic cases interpreting EU law in the area of holiday pay. So we had all this EU retained law, which was great, kind of knew where we were broadly with that. So that was good, but all good things must come to an end. And that's where we come back to the retained EU law, Revocation and Reform Act 2023. Because in terms of EU law and Brexit, the supremacy of EU law ended at the end of 2023. And so what the government needed to do is to ensure that we either got rid of or assimilated all the laws that we wanted to keep. So that's been quite a complex process. And if any of you have been following that, then I'm sure you'll know that. But basically what this piece of legislation does, or tries to do in a simple way, is to assimilate all that body of the retained EU law into our domestic legislation, unless any of it is actually revoked by the UK Parliament. Now, of course, our government, the UK government, promised everybody that there wouldn't be a bonfire of employment rights. So true to its word, it has not done very much to revoke any of our EU-derived employment law. There have been some things, you'll have seen some changes to TUPE and the like, but one of the areas that it has decided to take steps to restate or codify is around the working time regulations and working time. And that's because the retained EU Revocation Reform Act doesn't just allow the government to revoke laws, it allows them to basically restate it or vary the law to allow it to make sense in a UK context. So that's really where we come back to these, the Employment Rights Amendment, Revocation and Transitional Provision Regs. I'll call them the ER regs throughout the course of this particular webinar. They've been informed by a few consultations that took place in the course of last year. You might recall those. One in particular was launched to try and look at the effects of the Harper against Brazel Trust case, which was in the Supreme Court, which you'll all remember, and which is about part year workers. And Will's going to talk a lot about that later on in the webinar. But it's important to note that the stated intention of the government and business, Department of Business and Trade is trying to just simplify and codify the existing EU principles on working time. So what we should really see is nothing different from what we're already used to through the ECJ case law and the UK case law that we've seen. But unfortunately, as we're going to talk about in this webinar, it's not clear that the government has actually managed to achieve that simplicity and clarity that they were actually aiming for. And that's because a lot of the language that's been used in the ER regs, amending the working time regulations, is already giving rise to a lot of questions. There are a lot of people out there picking them apart. And of course, as soon as you start to do that or have any areas of uncertainty, then that creates the risk of dispute and creates the risk of satellite litigation, and there's a lot of talk going on about there being satellite litigation. So I'm afraid that there is a real risk that if I have not retired by the year 2034, that I will be back here in 2034 talking about holiday pay. I should say that there is some statutory guidance which we've referred you to on the slide, which should help steer you through some of the changes that we're going to talk about, but it does come with a word of caution. A lot of people have been very critical about the guidance, arguing that it doesn't actually reflect what the regulations say or what the amended working time regulations say. And also the guidance itself does have a bit of a disclaimer right at the very start. So it makes it very clear that it is non-statutory. It doesn't provide definitive answers to all queries. And that if you are looking at it, you shouldn't rely on it in any specific context without also taking advice, whether that's legal or advice from somewhere else. So that's kind of the background to where we've got to and why there is some new law. What does this mean for employers and employees? Well, the aims of the regulations, or what the ER regulations seek to do to the working time regs, are a number of things, but we're going to focus on three of the key things today. The first thing is that it's trying to put a definition around or codify what normal remuneration is for the 4 weeks of basic leave. That's, I suppose, in old money, we called that Euro leave. So it's trying to define what pay is and what pay elements should be included when you're calculating a week's pay for the purposes of carrying that basic leave. Then we're also going to look at how the ER regs amend the working time regulations to codify the rules that we have from case law, both ECJ and domestic case law, on carrying over leave into subsequent leave years, for example, where there's been sickness absence or family type leave. And then most significantly, we are going to look at the new regime, which is set out in the ER regs and amended into the working time regs, which is the systems of holiday accrual for these part year and irregular workers, and also the introduction of new options for how to pay holiday pay. And we see the resurfacing of the dreaded 12.07 percentage. And I'm leaving that part to Will, because anybody that knows me knows I'm not good at sums and percentages. So there are a few other bits and pieces that the regulations deal with, but these are the key bits. There are some provisions, for example, removing the COVID carryover, which you'll remember was introduced to allow people who couldn't take leave during the COVID period to allow them to carry over longer than they otherwise would. Those provisions are a bit less controversial, so we're not going to focus on those today. Okay, so normal remuneration, what does this mean now? Well, we're all, I think, now very used to all these cases that we've gone through telling us what it is, what additional pay elements need to be added in when we're calculating a week's pay for the purposes of calculating what's called Regulation 13, your basic leave, that is the 4 weeks leave that came from the Working Time Directive. So it's sometimes called the basic leave, sometimes the Euro leave. But that portion of leave is now, you can see on the slide, the old definition, if you like. The new definition is going to be an entitlement to a week's pay for each week of leave, and a week's pay is to be calculated in accordance with the new working time regulation 16.3ZA. And we know we're in trouble when the letter Z appears in a statutory provision. That doesn't feel good. The one point, I guess, that's useful just to mention here is that the government, as you might be aware, did consult on this notion of creating a single unitary pot of leave so that everyone would just have 5.6 weeks and we wouldn't need to worry about dividing up into 4 weeks and the additional 1.6 weeks. They have not done that. So we've still got 2 pots of leave and that's important for the purposes of calculating normal remuneration for the 4 weeks. And it's also important for carryover, but noting that there are different rules in place for irregular and part year workers that we'll come back to later, where there is a sort of composite 5.6 weeks. So if we move on to the next slide, let's think about whether 16.3ZA actually does change the law. It's meant to codify it. That's what we're being told. This is what 16.3ZA says. You can see it on the slide. In summary, it means that you will have to include payments which are for intrinsically linked to the performance of tasks which somebody has to do under their contract. Or it can also include payments for provisional or personal status relating to length of service, seniority, or professional qualifications. And it can also include payments such as overtime payments that have been regularly paid to a worker in the 52 weeks prior to the calculation date. Now, noting that these are not and, so it's not payments intrinsically linked and regularly paid. These are separate things. So is this the same? Well, let's look at the sorts of payments that we've seen through the case law so far. If we move on to the next slide. So things like commission payments, overtime, standby emergency call-outs, shift premia, certain allowances for doing tasks at particular times. We know from the case law that all of these things are intended to be included in the calculation of holiday pay. And we know that from a number of cases. So we obviously saw the Locke case, which was about commission payments. We've seen the Flowers Against East of England Ambulance Trust on overtime payments. We've had the Bear Fulton Scotland case. All of these cases, which you, as I'm saying them, you will probably be recoiling in horror remembering them as we've gone through them over the years. So they're probably all included, but it's very important to note that in the way that our domestic tribunals and EATs have interpreted the ECJ case law has been very much to focus on the language which is around payments which are regularly made over a sufficient period of time and normal pay. So they talk about normal pay elements being regularly paid over a sufficient period of time. But the new regulations, Regulation 16.3ZA, does not say that. It doesn't use the word normal pay. It does talk about regularly paid, but if you will see those three different kinds of payments. The last one, the third one, are payments which are regularly paid in the preceding 52 weeks. But there's no requirement that a payment which is intrinsically linked to the performance of tasks is one which is paid sufficiently regularly. So the language arguably that has been used is absolutely right. The drafter of the regulations and amending the working time regulations has taken the language directly from ECJ case law, but it's maybe just slightly different from some of the language that our domestic courts have used. So if we move on back to where this has given rise to a lot of debate about whether some payments that we thought were out, so the payment of annual bonuses, for example, whether they are brought back into the mix. Do we now have to actually pay annual bonuses? Because at the end of the day, if those are performance related bonuses and they're calculated according to people's tasks, if they've had objectives, then surely they would come under the first category of being intrinsically linked to tasks which somebody's been asked to carry out under their contract. And there are arguments which are really quite compelling out there. Some leading cases are suggesting that there is an argument to say that this is just a restatement of EU law. Bonuses should always have been included. We just haven't been including them because they are intrinsically linked. So we are probably going to see a little bit of a debate about this, because on the other hand, of course, it's clear that the Department of Business and Trade still have as this principle normal pay. And can you really say that somebody who gets an absolutely massive annual bonus, as some perhaps in the finance sector do, that those they're not normal pay, they're not something that you rely on and you get as part of your normal pay, and they're not paid regularly. So why should they be included, especially if the law is meant to be a restatement? I suppose one other point to make on that is, although these regulations are meant to be a restatement, they have been introduced under all of the powers which allow revocation or amending legislation. So arguably bonuses might now actually be included. We'll have to see what might happen there. So if bonus is something which is a live issue for you, we're not saying that you're going to have to start suddenly including them, especially large annual bonuses, but it might just be that you have to think about that, think about how they're structured, because there are arguments floating about around whether, if they're not linked to tasks, with their company-wide bonuses, which can't be linked directly to an individual, can we count them out? All we can basically say at this stage is that because wherever you create a degree of uncertainty, that is where you're going to somewhere create an element of dispute and potentially litigation. And I think one of the areas where I particularly see this as becoming an issue might be at the end of employment for people who get significant bonuses, because what we now see in Regulation 13.17, sorry, I know I'm saying lots of techie regulations at you, is that if any element of pay, 16.3ZA pay, has not been paid and there's been an underpayment, then the right to that pay and that leave carries forward and you can make a claim for it under the regulations on termination of employment. And that is in keeping with some of the ECJ case law that exists on this. So I suspect that what we might see, or where we might see this coming up as an issue, is perhaps senior people, people with big bonuses, trying to, under a settlement agreement at the end of their employment, making arguments that they should have been paid their bonus as part of holiday pay and haven't been for many years. So who knows, we might see that. The next change that I'm going to talk about before I can move on to Will is carryover of leave. Now, the general principle here remains the same, and that is that statutory leave is to be taken the year that accrues. But in the spirit of codifying all of the case law that we have on this, there are some exceptions. So if there is a relevant agreement in place, then that can allow for the carryover of that additional 1.6 weeks of leave, which is under Regulation 13A of the Working Time Regulations. And also all statutory annual leave, if it's not taken due to maternity or family-related leave, can also be carried over. And in both of those cases, the leave can be taken in the next leave year. But we're also going to have carryover, and again, this comes from the case law, so it's a codification. If you are unable to take leave because of sickness absence, then you will still be allowed to carry over the 4 weeks of basic leave, and that has to be taken now within 18 months of the leave year to which it relates. And you'll remember the case of Schultz, which mentioned that 18-month period. So that is a codification. And also the 4 weeks basic leave will carry over if an employer has failed to recognise the right to annual leave or paid leave, a worker hasn't been given a reasonable opportunity to take leave or encouraged to do so, or the employee or the worker hasn't been informed that the leave is not taken by the end of the leave year, it will be lost. So again, this is intended to be a codification. If we go on to the next slide, I'm going to flag a couple of points which might be up for debate again. So in sickness carryover, our new and amended Regulation 1315 talks about carryover where there's an inability to take leave due to sickness. But what if a worker is just unwilling to take leave? Now, I think what has probably been the case is that the ECJ case law, there's a couple of German cases that made it very clear that, that this is around the unwillingness and inability is what is covered here. But the regulations don't actually say that. So is that what they mean? Presumably they are. So if a worker, they might actually be able to work, but if they're still sick, or sorry, they might be able to go on holiday, but if they're off sick, they don't have to take their leave. So there's a bit of a question mark over whether this regulation is actually properly captured as it is intended to do the existing case law. And the other area which is important to note, and I think this really is something which might be quite significant, is that it arguably is the case because of a couple of German ECJ cases that employers have always had to make sure that employees and workers know that their leave and what their leave is, and the fact that it might be running out, and that if they don't take it before the end of the year, they must remind them of their opportunity to take it, and remind them about what might happen if they don't. So there is ECJ case law that says that is a proper interpretation of the Working Time Directive. And we don't think employers really here have been probably doing that. So question whether employers should really now be thinking about having a policy in place that specifically states what happens and how you take your opportunity to take your leave and what happens if you don't. Will you need to have a tracking system to watch what leave people are taking? Should you remind them at intervals during the year where they are with their leave? Do you get near the end of the leave year and do a flag to people who haven't taken it and remind them that if they don't, they'll potentially lose it? So these are some of the questions and processes and procedures might be needed to be put in place to address that very express part of the law. And I'm just going to mention before I hand over to Will the effect of the Agnew case, which we're not really talking about in any detail today. That was the Supreme Court case which we had at the end of last year, but important just to note that in that case, whenever a period of leave is taken, it's deemed to include be a little pot that's made up of your basic leave and the additional leave. So if you do want to take advantage of the rules or the less onerous rules for the additional leave and for carryover and calculating a week's pay, then you probably want to make it very clear in your holiday pay, in your contracts or your policies, that leave accrues in a particular way, and the basic, there are two separate pots that you're applying different rules to. And with that, I'm going to hand over to Will to deal with the more complex area of irregular workers and part-time workers.
Thanks, Lynn. So I'll start just by saying that the concept of irregular hours and part-year workers and sort of the statutory codification of it is largely introduced to deal with what was a perceived unfairness in the Supreme Court's decision in Harper Trust v Brazil, which was basically that it didn't really matter how much of the year somebody who was a part-year worker actually worked. They were still nevertheless entitled to 5.6 weeks of annual leave. And that seemed to be a bit unfair for people who were full year workers who might only get the same entitlement. So we've now got the rights of irregular hours and part year workers in the new regulations. They will apply to workers with leave years starting on or after the 1st of April 2024. So query if there could be the ability, if you're not already started this holiday leave year, that you could change it and maybe start your leave year towards the end of March, which would then mean that this wouldn't apply until the end of March 2025. But in the meantime, really all that means is that the Harper Trust decision might still apply to your casual workers, and so they might still nevertheless have more annual leave than seems fair. So if we now move on to look at the actual definitions of a part-year worker and irregular hours workers, I've put them up there as they are in the new legislation. And the main thing to be aware for irregular hours workers is that it applies to people who have a number of paid hours that they will work in each pay period during the term of their contract, and under their contract it is wholly or mostly variable. And again, there's a bit of imprecision in the language here. For instance, does each pay period mean every pay period, and does that mean that under the contract every pay period the amount of hours has to vary? And you could see how that might end up in disputes where somebody might have a contract that gives them a minimum number of hours, say 8 hours per week. So under the contract, their hours aren't wholly or mostly variable, but in practice, they maybe work 10 hours one week, 12 hours another, 16 hours another, that sort of thing. And also there might be difficulties where somebody might work irregular hours for the majority of the year, but what if over sort of 3 pay periods, 4 pay periods, somebody works consistent number of hours? Does that then mean that they are no longer an irregular hours worker? And at the moment, it doesn't really appear that the regulations have any mechanism to deal with somebody who changes partway through the year. And then if we look at part year workers, the definition there involves having to be required to work for only part of the year. So far, so good. You have to have periods within that year of at least 1 week where the individual is not required to work and for which they are not paid. And again, there's sort of scope for difficulties arising here in terms of people who might work annualized hours. So where it's well known in advance that their hours month to month or week to week might vary because of seasonal fluctuations or changes in productivity, but where you nevertheless apply a sort of monthly salary so that the pay doesn't vary so much and so that it doesn't fluctuate so wildly. In that scenario, there might very well be periods where you know the person isn't going to work and they're not actually really being paid for not working. It's just that you've averaged the pay over the period. And the government guidance suggests that those people would be excluded, so they would not be part-year workers. But again, as Lynne had sort of mentioned, it comes with a health warning and it might not necessarily be fully compliant with the literal reading of the legislation. And so again, we can just see that there might be scope for some more litigation in this area. Moving on then, just to have a bit more of a look at some of the other points about part-year workers. You ignore any period when somebody was on sick leave or statutory, i.e. family-related leave. So you wouldn't become a part-year worker just because you'd been off sick for 4 weeks or because you'd been on maternity leave for 6 months. There's also a question mark over the fact that it talks about pay periods being a plural, and so would that exclude anyone who has a longer block of 1 week, but it's not more than 1 pay period? So as I say, just a little bit unclear, and a little bit of concern that there could be some more litigation here. So if we move on now to look a little bit at the holiday entitlement for these people, and remember we are only talking about these new irregular and part-year workers. Holidays for these people will accrue at the end of each pay period. Now, a pay period isn't defined, but for some people it will be pretty obvious. It'll either be, if they're paid weekly, that week, fortnightly, etc. And they'll accrue 12.07% of the actual hours worked. And for many people, that'll be a familiar figure, deriving from basically what the 5.6 entitlement was out of the working year left available. the regulations say that you can't accrue more than 28 days leave, but it also says that holidays for these people are calculated in hours and not days. So then what is a day's leave if it's measured in hours, particularly if somebody doesn't work a fixed number of hours each time they're working? And the holiday accrues in arrears. So if you are paid monthly, for example, what does that mean for a January to December leave year where somebody doesn't know what they're going to be working in December? You won't actually be able to work out what their leave is until the end of that period. So does that then mean that they have to carry some leave forward into the next year? Or do you just guess what might be a reasonable amount of leave for them and pay to be able to take? There are some rounding provisions. They're not particularly exciting. You round down if you end up at a figure less than half an hour. You round up if more. And there are provisions so that workers on sick leave will still continue to accrue leave. Same for people on family leave. And you look back using a 52-week averaging system to look at, well, how much was the person working per pay period? And then you charge that up by 12.07%. Unlike the other provisions relating to leave, which Lynne was covering, there is no distinction between your Regulation 13 basic leave and your Regulation 13A additional leave for these people for the purposes of carryover. It's just however much you've accrued and not been able to take carries over. Moving on then, the statutory guidance does give an example. I'm not going to go into detail on it here just because of the time that we've got left, but it's not particularly clear because the example uses somebody who does appear to actually have a relatively, not fixed, but regular working pattern, and it doesn't really work, I don't think, for somebody who's working completely different hours, casual staff, bank staff, that sort of thing. Moving on then to look a little bit about pay for these people. So far we've just been looking at the entitlement to leave. Well, there's two options now, and these are found in Regulation 16 and 16A. Option one is to pay an irregular hours or part-year worker on each occasion of leave that they take. So you look at a week's pay, you average it over the 52 weeks, you include the additional elements that Lynne had mentioned, so commission, all the things that we thought we were used to, and then you ignore weeks where no remuneration was paid or where somebody was on sick leave or family leave, just so that you give a bit more of a representative amount of what they actually earned. And if they have been on that sort of leave, then you would include additional weeks looking back a maximum period of 104, and then you just calculate their leave for that period taken. So you would have to do a calculation every time, and so it might mean that you come at a different figure each time. But if you get used to that and you've got good systems in place, it might not be too problematic. The other option, which appears to us to be the far more straightforward option, is to do rolled up holiday pay, where you would just at the end of each pay period, just add on 12.07% of pay as a supplement. So if somebody got £100 in that pay period, you'd add on £12.07. And you'd say, well, there you go. That's your additional holiday pay. Again, you need to include the additional elements as we know, so commission and all of that. So you don't just look at basic pay. And it gets paid at the time that work is done, but not when the holiday is necessarily taken. So you do still need to permit the person to take the holiday. Now, sometimes that might be really obvious. They'll just take the holiday in that month and that's great. But you just need to make sure that you've got some sort of recording mechanism for knowing that they have been able to take their leave. You would also, if operating rolled up holiday pay, need to show a separate line on a pay slip. And there's a similar provision for looking at a 52-week averaging system for people who have either been on sick leave or family leave. So in terms of practical steps, what do we think people should be doing here to cover off both what Lynne and I have been talking about? Well, the first is, are there any payments which you should now be including in calculations of holiday pay? So if this has prompted you to think, actually, we weren't complying with what the case law was before, perhaps you need to review that and start thinking about new ways of calculating what should go in holiday pay. Are your policies on annual leave up to date? And do they reflect the carryover rights for different kinds of leave? And when doing that, some things you could think about are, well, how do we go about encouraging our staff to take leave? Should we send circular emails out? Should we do it at regular intervals rather than just perhaps once a year? And then also, do you warn them that if they don't take their leave in the relevant leave year, it will be lost? And if you're not doing that, then you should start doing so. And lastly, for those who do have irregular or part-year workers, do an audit. So check who in your workforce this might apply to, and then review your current approach. to their accrual of leave and pay? Are your contracts and policies okay, or do they need to be amended to deal with those people? And then consider, do you want to introduce rolled up holiday pay? Again, are you contractually entitled to do that? And then make sure that workers who do have rolled up holiday pay still get the 5.6 weeks annual leave, so that they still take it. And make sure that you link in with payroll to make sure that anything administrative in terms of adding on a new line to show holiday pay is easy and straightforward to do.
Okay, thanks very much, Will. We are out of time. These half-hour sessions are intended to be quite quick, but hopefully that has given you a flavour of the changes that we've got. For those of you who are subscribers to Workbox, our holiday pay pages have been updated, so you can access them and we'll be able to see the changes that are reflected there. And if you do have any queries on any of that, then please do feel free to contact Will or I. And in the meantime, we hope you all have a great day.